Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the Phia Group.
Hello, and welcome to the latest installment of the Phia Group's podcast, Empowering Plans. I am attorney John Jablon, and with me is attorney Cindy Merrell. Hi, Cindy.
Hi, John. How are you today?
I am doing fantastic. How are you?
I'm doing really well. We're coming off Derby weekend and headed right back into Sebro.
Oh, right. Yeah. Here in the Northeast, that's not really a thing that anyone cares about, but I know that it's a big thing down
deal.
where you are.
Yep. Big deal here in Kentucky.
Yep. Well, good. How'd your picks go?
My top pick got fourth, so I was just out of the top three. And then the rest of it, we don't want to talk about. Not so great.
Fair enough. Maybe you should do a consult with Corey Krieger next year, because I guess he's just the ace.
He did. He picked all of the trifecta. So that was pretty amazing.
That's fantastic. All right. Well, thanks for joining me, Cindy. When Cindy and I get together, it's always so fun because we work in totally different spheres in the self-funded industry, right? And we deal with such different issues, and it's not super common for something to transcend into both our worlds. But we've got an issue here today that we wanted to talk about. It's a recent case, and it primarily deals with the concept of usual and customary, but it transfers over into issues of state law and sort of why payments are being made. And it is a really interesting insight into everybody's lives here. So it'll be a fun topic. And the recent case here, it is Jenkins v. Aetna. And it builds off of the old case from, now 20 years ago, Aetna v. Davila, which is a really interesting case. And I know that that is one that many of you listening will be familiar with. We'll go over it somewhat briefly. But the gist of this case, the Jenkins case, during the pre-certification process, a TPA representative told the provider that the plan was going to pay usual and customary. But the plan terms were vague, and they didn't even use the term usual and customary. What they did was they defined payment as health plans usually do. It didn't use usual and customary again. And then the plan paid a rate that the provider said, well, this is not usual and customary. So the language of the plan left it to Aetna's discretion to really decide which of a myriad of factors was going to be used in a given case. And what the court ultimately said, spoiler alert, it's impossible to know what benefits were actually going to be paid because it was at the discretion of Aetna to basically take all these seemingly reasonable factors into account and then just decide to use whichever one it thought made the most sense. Now, that's an extremely common thing among health plans. And language like that has largely fallen out of favor. And plans are usually nowadays using some sort of more clear and objective metric. I mean, for example, Medicare-based payments is a hugely popular metric that a lot of plans use. And that's, of course, the traditional notion of what we call reference-based pricing, right? The entire industry has known that now for, quite some time, since before I came to Phia 11 years ago. So when the court said during the pre-cert process, the promise that the provider would be paid usual and customary, the court said that that was essentially a separate promise from whatever the plan document said. Therefore, that separate promise, that could be litigated in state court. That was no longer an ERISA issue. It was a separate promise that was made by Aetna. So it's very different from the way a lot of us think about self-funding, right? We think of the plan document as the be-all, end-all of benefits. No matter what you say or do, whatever's in the plan doc is all that matters. But that's not the case. Now, this case is not novel, right? We've had cases that have talked about things like this before, but this is a very recent one. And UNC or other out-of-network payment methodology is a topic that's near and dear to so many of our hearts. And this just presents a really interesting example of where our court systems can diverge in terms of state and federal court. And of course, there's the whole topic of ERISA preemption, which we all hold so dear. But an important reminder here, it's not absolute. Not absolute. So, Cindy, when we talk about UNC, I think that most of our listeners probably have an idea of what they think of as usual and customary, right? Because we are generally, the people listening here, we are in the insurance payment industry. But I know that you've got a checkered past
Yeah.
from this perspective. So can you tell us
Sure.
what UNC used to mean for you and what your old role was?
So, for the listeners that don't know, I used to be one of the personal injury attorneys. I say that, but
Ooh,
I do say that
just
with
kidding.
pride because I did learn a lot of how to practice law. I will say for me, usual and customary, when I was in private practice, it was over 10 years ago, but that is something that we use to determine a member's damages in a subrogation case, or if they had a personal injury matter, what the plan paid. Defense was always telling us that that was the plan paid too much and that was outside of the usual and customary amount. So, looking through this case, what's been interesting to me is the way usual and customary, what that means to each person. When John and I were talking about, we were prepping for this podcast, I was like, oh, okay, so usual and customary to the payors means something very different than what my understanding was when I'm looking at damages. And we were always trying to limit or expand, depends on what the number was, what that usual and customary amount meant. And it was always a point of contention in litigation. But it means something very different to you, John. So why don't you fill me in?
Yeah, no, that's so interesting, right? And it really underscores how usual and customary means different things to so many people. And that's one of the central themes of this case and probably the most important thing here. So traditional, usual, and customary, right? I mean, it can be defined in various ways, but the main questions are what is usual? What is customary? How big is the geographic area, right, where the charges are measured? It usually just has something to do with what area providers normally charge, right? It's not necessarily the average, it's not necessarily the mean, the mode, the median, whatever you want to call it. Different TPAs and plans have different ways of calculating UNC. And when it's very, very vague in a plan document, right? I mean, there are some plan docs we see and really some stop loss policies, for instance, that still have really vague language like that. They say something like, we will pay the usual and customary charge in the geographical area. That doesn't tell anyone anything, right? It's so incredibly difficult, or really it's impossible to figure out what the plan's going to pay. You can read that language, you can have all sorts of ideas of what it means, but there's no way to actually know. And traditional usual and customary is quickly becoming a thing of the past for many plans and TPAs. And Medicare-based pricing, databases like Fair Health, those are really popular for what we usually consider ground up pricing rather than top down pricing, right? I mean, when we're looking at the industry as a whole, we know that billed charges are completely meaningless. Billed charges are totally arbitrary. They're at the discretion of a hospital. I mean, even if hospitals have to publish their charge masters, they're literally allowed to put whatever prices they want in their charge masters, except for, I think it's 2 states that actually impose meaningful limits. But everybody else is just, yeah, sure, do whatever you want, charge whatever you want. And they say, really? Great, we will. So that's why a lot of plans start using Medicare and Fair Health and things like that to, sort of plug in a claim and you figure out what's reasonable for the claim, irrespective of what the provider may have billed, because again, the provider's charge is arbitrary. And things like Medicare-based pricing and Fair Health are generally considered not arbitrary. But here's a hot take for you. Usual and customary in this manner with something like Fair Health, that's a form of reference-based pricing. A lot of people think of RBP as strictly based on Medicare, but when you use a database, I mean, that's your reference, right? The letter R in RBP is a reference, and Fair Health is as much a reference as Medicare is. It might not be quite as objective in the sense that it's not set by the government, but is a reference nonetheless. RBP is not a legal distinction, right? So when you're talking RBP or non-RBP, it doesn't matter. You can call it whatever the heck you want. You could even come up with your own name, but it challenges the way that people usually think of payments. And it's so interesting here because when Aetna told the provider that it was going to pay based on what was usual and customary, the provider thought, okay, I have a good idea of what that means. The provider didn't look at the plan doc. The provider just said, oh, usual and customary. Great. I get paid that all the time. That's perfect. And, it's funny because a lot of providers say, oh, usual and customary. Great. That's what we charge. Well, Cindy, that's a perfect example of when different people defining the same term in different ways reach different conclusions, and that's a problem. And here, I think that was illustrated very well. So in this case, right, the plan, as I said, Aetna left itself a ton of discretion to decide what factors it made sense to account for in a given case. But that can be a double-edged sword. On one hand, the plan can choose whichever factor yields the smallest payment. And the discretion is kind of funny because discretion is usually meant for when language is ambiguous or when facts are not clear. But discretion is not supposed to be a tool for cost containment. It's designed to be a tool to make sure that the plan covers all its bases, even though you can't include literally every contingency in a plan doc. But it's not supposed to be the case that the plan just has discretion to determine payment whenever it wants. And like I said, providers usually have their own notions of what usual and customary is or should be. And by not defining it in a really clear, meaningful way, that's when the court basically said, well, we're going to send this back to the trial court. And when you said you're going to pay them UNC, we're going to tell the trial court to figure out what UNC means. And Aetna said, but the plan document talks about a payment. And the court said, we don't care. This promise you made to pay UNC, separate from the plan, outside the plan. It's sort of a matter of the representative misquoting the terms of the plan, and that can be a real problem, right? I mean, takeaway number one, if nothing else, make sure that your claim staff knows exactly what the plan says and try to use the same terminology. Because if you talk about UNC, but the plan talks about something totally different, well, the provider might say, well, great, UNC, that's perfect. I know exactly what that is. So Cindy, I mean, in the subro world, as much as anything else, how important is good plan language?
Oh, good plan language is the only way I can get a good recovery. So it's vital to what we do every single day.
Absolutely. I'm glad you said that. I was worried for a second that you were going to say, don't worry about it. Not really, though. I knew. But yeah, when plans are talking about cost containment in every way, good language is the absolute key. Whether it's limiting payments to begin with or recovering payments, strong plan language can really make or break a case. And the interplay between state and federal law can really become important when plan language is either not as strong as it could be or when somebody makes a promise outside the terms of the plan. And Cindy, I know in the subro world, we've got these crazy things called signed subros, right? And sometimes plans will request them of members and sometimes they return them, sometimes they don't. Can you talk a little bit about state and federal law and how signed subros can sort of implicate state law, even though a plan might be otherwise solely governed by ERISA?
Sure. So let's pretend that we have a plan that has the best language in the whole country, the good Phia subrogation language. And then the plan requests that the member on their own unilaterally, without any Phia's input, has requested a signed subro statement as a separate contract, a separate agreement saying, I, John Smith, agree to pay the plan, however they want to say it, but let's say that is inconsistent with the plan document. Well, now that plan may have now created a contract that's going to be controlled under state law, which is not usually a good thing, because when we start going to state law, we're losing that federal preemption, which allows the plan to seek 100% recovery. When we have a problem with those signed subrogation statements, it's creating a separate contract when it's completely unnecessary, because we already have good language in that plan document and we are in federal court with greater right of recovery.
Yeah. And, subro, of course, can fall victim to state law if you end up in state court. Something like payment rates and usual and customary determinations, state law is not quite as unfavorable as a lot of the so-called anti-subro states are. But the great thing about federal court is that it follows ERISA precedents and it knows ERISA. What we see overwhelmingly often is that when an otherwise ERISA case ends up in state court courts don't know what they're talking about. State courts are even more unpredictable than federal courts, and they look at things in a traditional insurance vacuum, and it's not great. That's one of the big reasons that plans really love their ERISA protections, right? In addition to the broad protections that ERISA grants outside of court, once you're in court, ERISA can really, really help because of discretion and because of sort of the general knowledge and expertise of the federal courts. There's a reason we've got that separation of powers in the judicial system, because states know state law and federal courts know federal law. So it can really get confusing when you end up in state law and try to make ERISA type arguments. A lot of the times the state courts will say, well, no, we go based on state law in this state court. And that's when you kind of do a facepalm and you're in a little bit of trouble. It's not necessarily a bad thing, but it so often is. And really, when you're looking at state court, you're looking at a greater amount of consumer protection than you have in federal court, because federal court gives the plan a huge, huge number of rights that state courts generally don't give to health plans. And when you're talking about a promise that's outside the plan, like the promise to pay UNC, irrespective of the terms of the plan, you're probably looking at a case where the plan participant is going to be protected more than the health. So yeah, ERISA and state law, the interplay is really interesting. And there's the Davila test. There's Aetna v. Davila from 20 years ago, back in 2004. Essentially, that case gave us two prongs that we can follow when we're looking at whether something falls under federal law or state law in terms of enforcement. Prong one, it checks whether the suit can be brought under ERISA. That's prong one of two of Davila. In this case that we're talking about today, yes, the suit can be brought under ERISA. It doesn't necessarily have to be, but it can. Prong two, is there an independent legal duty that exists outside of the ERISA plan terms? That's the central question for prong two. And the court decided, yes, in fact, there is. When the representative during the pre-cert process said, we'll pay you UNC, that was outside the terms of the plan. The plan didn't actually say that they would pay UNC. And what the plan did say, it didn't define as well as the court would have liked. So prong two is also satisfied because the claim was not based only on interpretation of the plan. What the court said is that, look, this promise to pay UNC, you can litigate that without even opening a plan document. You literally don't need to look at a word of the plan document in order to decide what usual and customary is. And I said, well, how can that be? Right? I mean, the plan document is what defines usual and customary. And the court said, first of all, no, you didn't use the words UNC. And second of all, what you paid does not quite comport with what the plan document says at first glance. So this is going to stand, and the trial court is going to essentially look into what constitutes UNC in its opinion, probably with a good look into state law, which is where this might become especially bad for the health plan. And, preemption is sort of shattered in this case with respect to that promise to pay UNC. And that's the gist of the case. I think through this discussion, Cindy, we've touched on all the things that we wanted to talk about. I mean, there's state law, there's Davila, there's subro and signed subros. But I think if I've got one piece of advice based on this claim, it's make sure that when doing pre-cert, your staff sticks to benefit summaries and doesn't promise any particular payment amounts that might not be supported by the terms of the plan. It's sort of, Cindy, it would be like if somebody called you and said, hey, do you guys have subrogation rights? And you just sort of rattled off some default rights that you're not even sure are in the plan, but you're just sort of talking about what you would like the plan to be able to have. I mean, that would be a disaster, wouldn't it?
That would be awful. And I'll tell you what, one thing I've noticed is when I'm working on these, you would expect that each plan document is unique. What we need to do is make sure that people are reading their plan documents and they understand what specific language is being used. You don't need to reinvent the wheel. If it is in there, that language is in there, repeat, be a parrot, use that language, the same language in your plan document.
Yeah, that's great advice. Absolutely it is. And the other thing to take away from this, of course, is try to make sure that you define what you're going to pay, right? I'm certainly not saying you should put a dollar amount into the plan doc, but the plan document should be written in order to allow somebody to really be able to figure out what benefits are going to be payable. Even if it's based on Medicare or Fair Health or something, it's just not independently verifiable when you give 10 factors and say, yeah, we'll choose one. It's not ideal. So try to avoid that, and whenever possible, be as specific as possible in your plan doc, in your EOBs. I mean, really in all your correspondence. This is designed to be a transparent process above all else. And that's one of the reasons that ERISA gives you protections, because when you make everything transparent, you get sort of the benefit of the doubt. But when that doesn't happen, you don't. So Cindy, any last thoughts before we let our listeners go?
No, I think that we did capture everything. I just wanted to say thank you for bringing this up and bringing in subrogation to this, because I do think it is parallel, and I do think it touches on all parts of our job.
Absolutely. Yeah, everything's related. It's so funny. We just every day we see new connections, and I'm like, oh, crazy. Amazing. Yeah. But great. Well, thank you so much, Cindy. This has been fun as always. And on behalf of Cindy and myself, John Jablon, thank you so much for tuning in. And please don't hesitate to reach out to Phia if you need anything, because we would love to help you empower your plans. Thanks, everybody. Take care.